Hello, everyone. Thank you for coming back to the YouTube channel and watching. And today I have a very special guest. In fact, I think I can probably say this is my favorite guest that I've ever had on the show because it is, in fact, someone that I am married to and the mother of my children. Marla Neufeld is on the show with us today. Marla is also a lawyer, and she's going to get into what she does. She does not work with my practice. She has something totally separate and different and pretty unique. And I want to kind of set it up before we get into what Marla does. So, as an estate planning and elder law attorney, it really is all about protecting the family, right? For my more elderly clients, it may be about preserving what they have to pass on to their children and maybe even their grandchildren. And certainly, even though our firm is called Elder Needs Law, we don't only work with the elderly. We do lots of general estate planning for young families as well who may have young children or maybe planning on having young children. And we always want to be a resource for our clients. So when people come to us and they sometimes divulge personal information, such as my granddaughter or grandson is having fertility issues, or we as a couple are having fertility issues. I always like people to understand what's available to them. And I think that is hopefully a great segue to introduce Marla Neufeld, who is a reproductive technology surrogacy attorney who helps couples who are having fertility issues have their children. Marla, please tell us more about what it is you do.
Sure. Well, first of all, thank you for the incredibly sweet and incredibly romantic introduction. That might be my first romantic introduction on a Zoom call that I've had to date. So thank you for having me on your YouTube channel as well. So for our listeners today, you might not know that Jason and I had difficulty getting pregnant, and ultimately we grew our family through the assistance of a gestational surrogate. So Jason and my embryo was transferred into another woman who helped us have our twin boys. So while we were going through the entire surrogacy process, one of our first meetings was actually discussing having our estate plan put together. Because for a lot of couples growing their family, having a child is really the precipice of like, oh, we should have an estate plan. What happens if one or both of us dies? Who makes medical decisions on our behalf? So these are things that, quite honestly, a lot of people just don't even think about until they have young children to start considering in their life as well. So I always suggest for any of my clients going through the surrogacy process, or anyone going through IVF or reproductive assistance, that they speak to an estate planning attorney to make sure that they have their wishes codified on what would happen if something happened to them. So, Jason, I'd love to hear from you. What happens if a family doesn't have an estate plan and something happens to the parents while the surrogate or the mother dies?
Yeah, there's a lot of different considerations that go into estate and incapacity planning when we're dealing with typically, it doesn't have to be, but typically a younger family with young children. So a few different considerations is what were to happen, and a lot of this, by the way, is we hope for the best, but we plan for the worst, right? So a lot of these things we're planning for may never come to pass, but if they do, we want to make sure we have the right plan in place. So for an example, if both parents or whoever the parent is becomes incapacitated temporarily, right? There's, God forbid, hit by the proverbial bus, in ICU for a little while, but they have young children who are not yet adults. Well, who takes over making decisions for them while you're recuperating? Who gets to take your young children to the doctor and access their medical records and help young children get the vaccines that they need and help make maybe important medical decisions for them while you're unable to, right? So that paperwork that you don't see in an estate plan for someone who has no children, who has fully grown children, we have to include those sorts of things in a family who is anticipating having children or have young children already. And then, of course, we get into issues of who is going to become the legal guardian if, God forbid, the current legal guardians pass away, or become incapacitated where they are never going to recover. And that needs to be provided for in their estate planning as well. And one thing that Marla and I were talking about earlier is Marla has encountered, and I have encountered, estate plans where the will or the trust isn't always contemplating children who are not yet born, right? So, or there's limiting language in terms of the contemplation of children who are not yet born. So let's just say we have a young couple who has one or two children, and they are maybe about to start working with Marla with a surrogate to have their third. And that child, if their will says, well, my wealth, my assets are only to go to my either children who I have now, or only children who are fully biologically related to me. And when you're going through the surrogacy process, sometimes they are biologically related to you, and sometimes they're not. And sometimes they are for one parent, they are biologically related, and for the other parent, they aren't. Marla, can you talk a little bit more about that, how that works?
Yeah, I mean, that's also a big part of my practice is I represent single parents or parents who are married or not married, but the way they create their embryo can be done in so many different ways. So as Jason said, as you said, it can be the genetics of both parents. They could use donor egg. They could just use donor sperm, or some couples donate and receive completely donated embryos where neither parent will be genetically related. So I've come into situations where, you know, my clients' grandparents have estate plans that are just dated. They haven't looked at it in 100 years. And, you know, the documents haven't caught up with the technology. So, you know, no ill harm, but at a grandparent's estate plan might, as Jason said, have biological requirements, which could literally exclude a future child from inheriting from their grandparents one day. So I think it's important to revisit with Jason when you're doing your estate plan or thinking about your old estate plan to make sure that the language is broad enough to include children that are born, you know, in the future, and not have excluding language that would have something like a biological link or exclude a child that might be brought into the family through adoption. That's also been language that I've definitely seen before with my clients.
And I like to say that if you have children or grandchildren who are struggling with a fertility process and you're looking for a professional who cares, a professional who has gone through the experience herself, there is no one better in the state of Florida than Marla Neufeld. And Marla, if anyone wants to reach out to you directly, what is the best way for them to do that?
Yes, for sure. Well, I'm happy to speak to anyone, grandparent, parent, expecting person that's going through infertility. There's quite a few calls that I have where it's my client and it's their mom on the call with them, which was how I went through the process as well with my mom by my side. So I'm happy to speak to any concerned grandparent that wants to be a grandparent or hopes to get more grandchildren. But to Jason's question, please feel free to reach out to me. You can call me at 954-761-2929, or you can email me at marla.neufeld@gmlaw.com. So Marla, M-A-R-L-A .Neufeld, Neufeld @gmlaw.com.
Thank you, my love. That was great. I love you.
Love you too. Thanks for having me.